Ms. Cohen.
Thank you, Justice Graney and the justices of the court. I'm here today representing the Harvard Crimson on an important question of public access, specifically whether the Crimson and the public may have access to records of the Harvard University Police prepared in the execution of their duties as special state police officers. This is a case in which the Harvard defendants, Harvard University, and the Harvard University Police Department specifically injected themselves into the public domain. That is, they sought and obtained the designation for the police officers as special state police officers under the Massachusetts statute. The case was decided below on a motion to dismiss. That is, the Superior Court judge found there were no set of facts on which the Harvard Crimson could obtain access to these records under the public records law.
What is the power that these police officers get, the added power that they get by becoming special state police officers?
As special state police officers, they have, specifically under 22C Section 63, the full power to make arrests on on property of Harvard, on or around the buildings and structures of Harvard, the land and structures of Harvard University.
Okay, that's the only additional power they get.
No, Justice Cordy, under the regulations as well, they have the power to execute search warrants also on the same premises.
Under the regulations, not under the statute.
That's right, under 501.4.
And the search warrants would be search warrants that they would obtain from the court, from a magistrate in the court system.
That they might obtain or that the other police might obtain, and they could be executed by the Harvard University Police Department. But
so those are the two powers that they get.
Those are the two powers that are in the statutes and the regulations. There's also discussion in the regulations 501.7, and this is in the brief of the amicus. I think it's the Student Law Center at pages 15 to 16 with respect to firearms. But since this was decided below without any discovery or factual development, we don't really know more about it except what is in the statute and the regulations.
I take it that private security forces on private property can surely stop people that are on the property, ask them questions. They may even be subjected to search if they're on private property, and it's not clear that they...
It's not clear, Your Honor. I think, let me first say that before you get to the issue of the powers, which I think is a factual issue, it is absolutely...
Isn't it a legal issue? How could it be a factual issue?
I think it's both a legal and a factual issue. The legal issue is what is the scope that is permitted by the statute, but there is much that is done incident to the power to make an arrest. And we don't know how that is exercised or what is done by the justices. The plain language of the statute, Chapter 66, refers to every person, this is Chapter 66, Section 10, every person having custody of a record made or received by an officer or employee of a State Department. And I believe it's uncontroverted for purposes of this appeal that the police department is such a department.
Well, it seems to me that, I mean, I'm just sort of reacting to the briefs here, that you may be correct that if, in fact, the officer is executing an authority, a power given specifically to him or her by the state to make an arrest, that the report with respect to that arrest ought to be a public document or ought to be available as any other such report made by a municipal police officer would be available.
I agree with everything. I think the Crimson would agree with everything you said, Justice Cordy, except that you referred to the report. And we really don't know if it's the report, if there are notebooks which are subsequently used to make a report. I think the Crimson's position is that every record that is generated that is not subject to a specific exemption under Chapter 4, Section 7, Clause 26 is a public record that is subject to disclosure.
So you would be seeking records of reports unrelated to arrests?
Well, We don't know what records there are because we haven't had any discovery, but I think...
Well, we know that, well, you do.
But-
You have been able to examine the log books, right?
Only the log books, because those are posted on the website pursuant to the Cleary law. That
And
is,
what do the log books contain? Arrests?
the log books have a skeletal account of the arrest and the incident. Whether there
So
is
they have
more...
arrests and other incidents in which there's not arrests,
Yes.
right?
Whether there is more that would be subject to scrutiny by the Crimson or useful to the Crimson. One can envision the Crimson doing an article, for example.
Well, I
that was-
understand why you would want this material. Trust me, I understand why you'd want the material. I'm
yeah.
trying to understand what your legal right to the material might be, why those records might be public records.
Because it is a public decision incident to the power to make arrest, to exercise discretion not to make an arrest.
But that's what I want to ask you about. You say that the power to arrest includes the lesser of powers, and I agree, such as the power to stop or to ask questions and not make an arrest. But if a state or a local police officer makes a stop that doesn't result in an arrest or just asks a person questions, which we say isn't even a stop, I don't believe they necessarily make a report so that they don't make a report that's subject to public records law.
We don't know what report they make, Your Honor, that the Harvard University police
No.
make.
I'm talking about state and local police. They make reports of arrests, but not just when they stop people on the street and ask questions.
If it's done by a regular police officer and a document exists, you could get it.
Exactly.
Okay, but here, excuse me, part of the problem is and this is I think what Justice Cordy was suggesting, you're arguing that because they have these powers as special officers, you can do this. But suppose they're doing things that have nothing to do with their power as special officers. They're involved in, directing, parking for some special event at Harvard. Your argument is that you get all records
Oh, no.
of HUPD.
Oh, no, that's not right. What we say is there should be a functional analysis applied to whether they were acting as an officer. And I believe in support of that kind of functional analysis, this Court would need to look at 4 prior decisions of this Court which support the notion of that kind of functional analysis, one being Attorney General versus Tillinghast, which is a case where the Court said this Court said that an individual was acting as an officer when they were acting with the sovereign authority. Another case would be Yates versus, I believe, the City of Lynn, which is cited in the brief, which is another case which addressed whether a police officer, in that case a full-time police officer, was acting as a police officer when he had been hired by a private employer. Another case is Commonwealth versus Leone, which specifically engaged in the kind of distinction that I think Justice Sussman is suggesting for Fourth Amendment purposes. So a different context, but the same kind of functional analysis.
So how would this work? If you were to make or someone were to make a request of the Harvard Police Department, it would be incumbent upon them to show that there is not an exception.
I think there would be...
That this would fall under that it would not fall under the public records rule.
There would be 2 inquiries under the judicial inquiry, which is expressly contemplated by Chapter 66, Section 10, which provides for judicial review of such a request. One would be, is this a public record? That is, was it made or received by an officer? So I think there the functional analysis would come into play. Were they acting as an officer for purposes of the record that has been created? And then there is a presumption under...
An officer of what? An officer of the state police?
A special officer of the state police. And then there's a presumption under Chapter 66, Section 10, Section C, that it is a public record unless it falls under one of the exemptions. And I think the exemptions that one can envision in this case might be the exemption under Section C for records that reveal private information about an individual, or the exemption under Section F, which deals with investigatory materials.
Can we back up for a minute? Harvard is a private university.
Yes.
The Harvard University Police are not a state or public agency, correct?
The Harvard University Police, only to the extent that they have been appointed as special state police officers under
that appointment
Chapter 22C.
That appointment is limited, is
Yes.
it not? Can they arrest for felonies?
Yes, they can arrest for felonies if it's on or around the land or structures of Harvard University.
Okay, there's no allegation here that with regard to anything you're looking for, they were acting for public purposes when these incidents occurred? That's not asserted in your complaint, is it?
There are not specific instances asserted. The arrest records were requested, not with respect to specific incidents. For example, if Harvard Crimson wanted to do a report longitudinally of what kinds of individuals were arrested and in which cases Harvard University Police Department exercised its discretion not to make arrest. For example, in cases of racial profiling, if there was differential treatment of people who looked like Harvard University students.
But the only time they're acting as special state police officers, the only time they're exercising that authority is when they make an arrest. Otherwise, they're acting as private security officers that can make all kinds of decisions about who to throw off the property and who not.
We don't know that from the record. They have the power to make the arrest.
But as a matter of law, the only time they are exercising the authority is when they make the arrest.
As a matter of law, that defines the outmost scope of their authority.
I'm just repeating the statute.
I understand that, and what I'm saying is that the statute defines the outmost scope, but it is relevant when they make the arrest. What are the nature of the citizens who are arrested? And those are, even if it were confined to that would be a public record. Now, Harvard University has argued that those records are elsewhere available. That also is a question of fact, and it's also a question of how the records are complied. And there is no exclusion under the statute for records that are otherwise available.
What if this was Walmart and their security officers had special police powers? Can we get at those records?
I believe you could if they have been delegated the sovereign authority of the Commonwealth to act as special state police officers.
So by reason of making them either special or municipal police officers, a newspaper could get out of all of Walmart's security records pertaining to how these people acted?
I don't believe you could get at all of them. I believe you could get at the ones that were necessary and incidental to the exercise of the functions.
So if we agree with you, every private entity up and down the pike where their people have police powers granted by either a city, town, or state are going to have to reveal these records.
And shouldn't that be an appropriate result, Justice Graney?
Why should it be?
Because where a private entity steps forward, as Harvard did, and seeks and obtains special power to act as public officers and special sovereign authority, why should that be hidden? Why shouldn't that have the transparency?
Can't the legislature make that clear if that's what it wants? I mean, as I understand, correct me if I'm wrong, I may misunderstand the sequence here. Originally, the logs of regular police departments were accessible, correct? Because they were public records, correct?
That's right.
All right. And I gather it took, the legislature perceived that it took a special amendment to come out and specify that the logs of places like Harvard University Police Department also had to be made available. Does that not suggest that the legislature previously thought they were not available because they were not public records, and the legislature has itself already carved out one exception that says even though you're private, we're going to make you reveal this. The legislature can say, for all the reasons you've articulated in your brief, we also want you to make records pertaining to arrests and stops and whatnot public. Hasn't the legislature already drawn that line and drawn it at logs?
Your Honor is referring to the Cleary law, and I also have looked extensively at the legislative history of that statute to see whether there's an inference one way or another that can be drawn about the legislative intent. I don't believe it can. It was a statute that was adopted in many jurisdictions. It came as a special package in that form, and I don't think you can draw any inference either way. I think to cite one additional case.
Under your theory, it's a totally redundant law.
The Cleary law?
Under your interpretation of the public records law, the Cleary law is completely superfluous.
Well, not really, Your Honor, in this sense, that the Cleary law requires a posting of the police logs in an accessible format. What we are asking is whether there is a right under the public records law, and it's entirely conceivable that it might have been redundant. This court held in the Cape Cod Times versus the Sheriff of Barnstable County, which is one case which is not cited in our brief at 443 Mass 587, that when a public officer's actions are only by virtue of the public office he or she holds, they are official acts. And what we are asking for...
Those records were unquestionably in the custody of someone who was a public entity.
And in this case, the records are unquestionably in the possession either of Harvard University or of the Harvard University police defendants.
What happens after an arrest or the execution of a search warrant and a report is generated or a return on the search warrant is generated? Are those documents filed with the Cambridge Police?
Yes, they are, Your Honor, but that is not an adequate answer here because...
Well, are the arrest records of the Cambridge Police automatically a public record?
I don't know if they're automatically what the...
I don't think they are. So that's what I can't... maybe there's something I don't understand here, but I don't believe that police reports... I mean, defendants wouldn't go to such a big deal in discovery to get the police reports if they were automatically a public record.
Well, what Harvard has suggested in this case is that the Crimson would have to go to the particular court and request them under the particular laws. These are records that are already available.
Police reports are not at the court. Nobody has them except the police department. That's what I don't understand, is that unless I'm missing something, you're making an argument that because they're public employees or public officials or whatever, you've got a right to their arrest reports. But local police arrest reports aren't available to the public.
What all the Crimson is asking, Justice Cowan, is that they be available in the same circumstances that they would be available.
They're not available except through discovery
or through a Freedom of Information Act request.
No, but they're exempted because of the ongoing investigation exemption.
If there is an ongoing investigation, and that's what this court held in Worcester Telegraph, that in each case, a case-by-case determination must be made as to whether these records are subject to production.
Your time's up. Thank you.
Thank you.
Mr. Swope.
Thank you, Your Honor.
Are Freedom of Information Act requests appropriately made to individual police officers or to the department through which they file their reports?
To the department. One of the issues in this case is that the statute does say that any person holding a public record is required to respond. That statute clearly can't mean what it says, or as I pointed out in our brief, we'd all have to turn over our marriage certificates and our kids' birth certificates if somebody showed it up at our door. The Secretary of State Public Records Division is obligated to issue regulations, not just permitted, but obligated to issue regulations. And under those regulations, they clarify that the records have to be held by a public entity. It's an argument that the Crimson doesn't address at all. I beg Your Honor's pardon, I haven't introduced myself so that I could answer that question. Jeffrey Swope, representing Harvard, the Harvard Police Department, and the Chief of the Harvard Police. May it please the Court. There's not a single case in this jurisdiction or in any other jurisdiction that the Crimson or any of the amici cite that make public records of campus police records, even when campus police are operating under delegated state authority. There was one case that they cited in their original brief, a Georgia Superior Court case, that did hold that they were public records under a much broader statute than the Massachusetts statute, and that case has been reversed.
If a city or town, is it the town of Cambridge?
City.
The city of Cambridge has a police officer that makes an arrest. The police officer generates a report, files the report with the Cambridge Police Department, and keeps a record at home, keeps a copy at home. Is a Freedom of Information Act request appropriately directed at the police officer for his individual or her individual copy?
The Secretary of State's regulations would say no, that it's directed to the governmental entity, not the individual.
Mr. Schwab, why isn't this, let's set aside who has possession of it. Why doesn't this fall quite clearly within the definition of a public record? I mean, it's a record prepared by an officer. He's exercising sovereign authority of the state in making an arrest. I'm looking at that narrow band we're talking about. When the officer actually exercised sovereign authority by making arrests, which the statute now authorizes him to do. Why isn't that a public record, the reports relating to that arrest?
Really for two reasons, Your Honor. One is that a public record is only a public record when in the hands of a public entity, as I was just discussing with Justice Spina. The second is that the term officer is a pretty elastic term. There are military officers. There are police officers. You all are officers of the state. I'm an officer of the court. Just using the term officer doesn't tell you much. As this court has held in a number of cases that we cite in our brief, you have to determine an officer for what purpose. Under the public records statute, it is an officer of a state or municipal entity. Under the campus police are not officers of a municipal or state.
And they've got to have those limited powers. I mean, suppose a riot broke out with 500 students and they have no power, and they call the Cambridge police and they say, well, look, we can't go down there. We got 5 accidents we're investigating. We got a murder elsewhere in town. So what are they supposed to do? Throw up their hands if they can't stop what might be a breach of the peace and so on?
That's absolutely correct, Your Honor. And I would suggest that if this court were to hold that all of these records became public records, it would be a significant deterrent. This is an optional power that university officers take. There are many colleges and universities throughout the state where the campus security force don't have this power. If holding this power made all your records subject to the public records statute, the court would be, in effect, deterring the exercise of just these authorities.
But they don't want all the records, do they? They only want the ones pertaining to where arrests are made in the capacity of being a special officer or sheriff?
No, I believe
they want the whole shebang.
I believe the Crimson's argument is that they want everything.
So if they pick up somebody and take them down to the infirmary, they'd want that.
I can't speak for the Crimson on that. They have... we have certainly pointed out that the reading of the argument that they make would lead to that result. And our concern, I want to just state that if I were sitting on the other side of this bench, one of my concerns would be, why does Harvard care so much about this? It cares for just that reason. A campus police officer in a community like Harvard is very different from a municipal or state police officer. They're dealing with students. They may not be teaching English or French, but they are part of the educational process of bringing students to be responsible adults. They deal with troubled students. They write notes to deans and to residence advisors. There are purposes that are served by a campus police department, so different from the municipal police.
Well, I'm with you on that 100%, except when they decide to arrest somebody, because then they've exercised the sovereign authority to place someone in jeopardy in a public court, and that seems to me appropriate, but that seems to me a dividing line. And I want to get back to your argument that public records are only records held by public authorities. That's not how public records are defined. It's a record made by any officer. It may be the obligation to disclose is only public authorities, but public record is a record made by any officer of the public.
That's certainly correct, Your Honor. The question is, when can you get it under the public records statute, and you may only get it from a public entity. So in theory, there could be a public record, as my marriage certificate is, sitting at my house, that I believe is not subject to the public record law, even though it is a public record.
But if a public agency had it, it would be. And
absolutely. And our argument is that the Harvard campus police and Harvard University are not a public agency. The Crimson has admitted forthrightly that Harvard is a private institution. The courts have so held. The other point, it does not go to the issue of whether or not it's a public record, but it is relevant to the balancing that this court is trying to do, that these records, when there is an arrest, do become public records somewhere else. Under the cases and court rules we've cited in our brief, they are filed with the court, whether it's a warrantless arrest or a warrant arrest. And so there is a record of the arrest that is available to determine the facts when a campus police officer does the arrest, but it's only for the arrest.
Was that changed at all by the new change in the Rules of Criminal Procedure 3G2 Are the reports filed regardless of whether it's an arrest with or without a warrant?
The last time I looked at it, Your Honor, that was correct, that they were still public records in both cases.
Well, also, you make the argument that the arrest records are available to the public just because the warrants are returnable to the court. Now, isn't it necessary to know the defendant's name in order to get the records? You can't just go into the Suffolk Superior Court and say, give me all your warrants returnable. You have to know the defendant's name.
That's right. And
so they wouldn't know the defendant's name.
Well, the link to that is the police log that Justice Sussman was talking about. And the argument there is exactly correct. It's very instructive, as Justice Sussman said, to look at how the legislature dealt with a similar issue. You're balancing public records and campus police authority. And how do you weigh those two? The original police log statute, which both makes them public records, which I guess they probably would have been already at a municipal police department, but also requires the retention of public logs. Used to say just police department in 1980. In 1991, it was amended to include campus police officers by express statutory amendment, and therefore those campus police logs now are subject to the requirement that arrests be indicated, complaints filed be indicated, that the name and address of the person who is arrested be indicated on the file. So you have the link that allows you to go in and get past the indexing problem in the Superior Court. Another issue that the Crimson has raised is whether this action should have been treated as a motion to dismiss or whether a factual record should have been developed. And the answer to that is that there is no case more suitable for a motion to dismiss than this one. Once again, the court is balancing a public record statute and an authority statute to the campus police. That's a pure question of law. Even the Crimson says it's ultimately a question of law. It should not turn, and it cannot turn, on the particular facts or circumstances at a particular university. If this case came up from a different university, there might be quite different facts about how they exercise their authority. And the court would not want to be in a position of pronouncing on the balance between the public record statute and the campus police statute, depending on the happenstance of the facts that were developed in one case or another.
Can I ask you an unrelated question, and that is, how is it that a regulation was promulgated authorizing Harvard police officers to execute search warrants on campus without, that's not in the statute. The statute only speaks of the power to arrest.
That's correct,
How does this
Your Honor.
come about? Is there also a regulatory authority in the statute that allows presumably the Secretary of Public Safety to promulgate such things?
Well, the Secretary of Public Safety has general regulatory power. There is not a specific regulatory power to expand the powers over those specified in Section 63.
What do these folks do if they want to get a search warrant? Do they have the Cambridge police do it, or do they prepare their own affidavits and go down and see the clerk? Say there's a drug ring running in one of the residents' houses.
Well, it obviously depends on the facts and circumstances of the case, Your Honor. And
Well, let's say they got an informant, and he says in such and such a place where the students are, there's a drug ring, and, they go through all the authentication of that. Do they go down to the Cambridge District Court and get the warrant?
They have that authority, Your Honor. And
Right.
they can either call the Cambridge police, as is sometimes done when the matter is especially serious. They can, as Justice Cordy indicates,
Or do it themselves?
under the regulations, not the statute, they have the authority to execute a search warrant. Frankly, there are also ways through the...
Well, execute must mean you can get it.
Yes, absolutely. And there are also opportunities through the dormitory staff sometimes to bring things to the police attention. So there's a whole range of ways in which matters come to the attention of the police. One of the issues that was raised was the recent case by this court in the Cape Cod Times case, which was not cited in our original briefs by any of us because this case was filed in the appeals court some time ago. But one of the amici has brought that case to the court's attention. And it's very interesting that Justice Sussman was right that that case very much decided that the records were in the hands of a public entity. But the argument was also made in that case that the records were actually in the hands of something called the Barnstable. This was the special sheriffs in Barnstable. Something called the Barnstable Sheriff's voluntary association or something like that, an admittedly private entity. And the court, instead of going to the question of, well, the statute says in any person's hands, therefore we can get them from the private association, expressly decided the case on the basis that they were not, the records being sought were not from the association, but were instead from the sheriff himself, a public officer, and therefore a public agency. There's also been the issue raised in the amicus brief about the status of the firearms authority of campus police. We point out in our brief on page 8 in note 3 that the firearms authority is independent of being appointed as a special state police officer. The regulations issued by the Commissioner of Public Safety expressly defer to the firearms licensing provisions that any private citizen can have as the basis on which campus police have firearms. And in fact, some campus police departments have their officers armed and some don't. So that the existence of firearms has nothing to do with the issue of whether they have campus police, special police authority as campus police.
Are all campus police, are all campus police special state police?
No, there are campus security guard at other universities, you mean, or at Harvard?
Harvard.
Yes, my understanding, I think I'm not sure if it's been pleaded, but my understanding is that all who have passed the experience and training requirements of the public safety Commissioner of Public Safety are.
But they're issued to, the status is issued to individual police officers.
That's correct.
It is not issued to the Harvard Police Department for wholesale distribution to.
That's exactly right, Your Honor. It's a one-by-one matter, and the appointments are renewed from time to time. The Georgia case that I referred to that the Crimson originally relied on, when it got to the Georgia Court of Appeals, dealt with the very question, and it's sort of relevant to what Justice Cordy was asking about. Well, if the officers have it, doesn't that make the police department a public entity? And the Georgia court expressly said no, that it did not in that case, that the officers had authority. That did not make the police department a public authority.
Thanks.
Thank you very much.